Hi everyone, I'm Matt Lockaby. I'm the founder and managing partner at Lockaby Law here in Lexington, Kentucky. And today we're talking about severance agreements. And if you're an employee who's received a severance agreement from your employer, don't rush to sign on the dotted line. Let's talk about what you need to do first. First things first, what is a severance agreement? Well, in its simplest form, it's just an agreement between an employer and an employee, generally when that employee is separating from employment with the employer and they're receiving some sort of money or other non-monetary benefit in exchange for waiving or releasing legal claims, and sometimes in exchange for providing some other type of promise or covenant, like a non-compete or non-solicitation restriction, maybe even a confidentiality obligation. So the first question we get invariably from every single client is, can I negotiate a higher payment? Can I negotiate an enhanced severance package? And the answer, frankly, is that it depends. In general, the fewer number of employees who are affected increases the likelihood that an employee can negotiate the final terms of that severance agreement. And this makes sense, right? If it's a restructuring or a mass layoff, the likelihood that that employer is going to negotiate the severance package for one person is significantly reduced because the likelihood is that they would then have to do it for all of the other employees as well. So the fewer people affected, the more likely the employee is going to be able to negotiate a better package. In addition, if an employee has a valid legal claim, the release or the waiver of which has value to the employer, again, the employee has leverage and more likely is going to be able to obtain better final terms under that severance agreement. Now, these are just general rules of thumb. They are not applicable in every situation, and there are always exceptions to these rules, but by and large, you can expect your severance agreement, that whether there's negotiations or not, to follow along these lines. So let's assume for a moment that you cannot negotiate the amount that you're receiving, right? The benefit, the financial benefit you're receiving under this severance agreement. Is all hope lost? No, because commonly there are other terms that employers are willing to negotiate that are non-monetary in nature. One of them would be an unemployment provision, right? Where we want the employer to agree not to contest a claim for unemployment benefits. Now, it's not the employer's decision whether or not unemployment insurance benefits are awarded. That's a determination made by the state or the relevant state agency. However, getting an agreement from the employer that they're not going to contest that application has some value for the employee. Likewise, there is a non-disparagement provision that is pretty common in most severance agreements. And this basically says that the employee is not going to say anything negative or disparaging about the employer or its management or the way it does business. And employers will commonly agree to make this provision mutual so that it won't say anything negative about an employee as well. Some employers are willing to do this on a blanket basis, right? The employer or the company won't say anything negative. Some employers prefer to name specific employees so that it makes it a little bit easier to police on their end. Nevertheless, this can be a really helpful provision for most employees. Again, depending on the nature of the separation or the circumstances, but can be a favorable addition in that final severance agreement. Finally, another common term that we have success negotiating is a neutral employment reference. Now, most employers, when they get an employment reference from a former employee's prospective employer, is to just confirm the dates of employment, the title at the time of separation, and maybe a few other details here or there, but these are really bare bones responses from most companies. However, it is helpful, especially in those situations where it's a rather acrimonious parting between the employee and the employer, to have this detailed in writing, who the reference will be directed to and what exactly the employer or a specific department or even a specific employee is going to say in response to that reference request. Finally, a quick word about deadlines. There is a federal law that requires employers to give employees at least 21 days, if not as many as 45 days, to review the terms of the severance agreement, but that only applies to the release or waiver of a very specific federal discrimination claim. It's an age discrimination claim under the Age Discrimination in Employment Act. However, in general, there are no state, local, or federal guidelines or directives when it comes to these deadlines. So, in a lot of instances, employees are faced with what might seem to be an arbitrary deadline of a few days or even a week to consider and sign the severance agreement. So, when you are presented with a severance agreement, it's important to act quickly. It's important to retain experienced counsel who has experience reviewing and evaluating and even negotiating these types of agreements, and get the advice that you really need to make an informed decision on whether to sign, whether not to sign, or whether to try to negotiate a better severance package. If you thought this video was helpful, hit the like button, subscribe, and we'll see you next time.